My present my presentation this afternoon is about e-discovery and data preservation. Broadly speaking, I intend to address what a company's e-discovery and data preservation obligations are in the context of litigation in California state and federal court, and how a company can ensure that it is complying with those obligations in a strategic and cost-effective way. My name is Jake Poorman. I have been practicing complex commercial litigation for over 15 years. My practice focuses on intellectual property litigation and in particular trade secret litigation, and I am a partner in Procopio's IP litigation group. All right, let's get into it. This is a graphic overview of the e-discovery process. I will discuss these steps in more detail, but this gives you the idea of the major steps, an idea of the major steps in the e-discovery process in a chronological fashion. The e-discovery process starts with information and governance, having a good handle on your data, then proceeds to identifying potentially relevant records, preserving those records, and then collecting those records that the other party has requested, or records that the producing party may rely on for its own claims and defenses. Once collected, these records have to be processed, reviewed, and analyzed to determine what records to produce, which records are then processed for production. Finally, parties must determine the best way to leverage those documents to support their claims and defenses. Starting from the beginning, one thing you can do to put your company in a good position to comply with its e-discovery and data preservation obligations in the case litigation arises is to know your data. There are some contexts in which electronic discovery has to happen without much advance notice, particularly in response to third-party discovery requests. For example, in California state court, the Code of Civil Procedure provides that a subpoena only has to be served with sufficient notice to give the responding party a reasonable opportunity to locate responsive records, and 10 days is generally considered to be presumptively reasonable. Similarly, federal law only requires that a subpoena allow a reasonable amount of time to comply, and typically 10 days notice is considered to be reasonable. I also note that as a general matter, a failure to timely assert objections in response to discovery in both federal court and California state court will constitute a waiver of those objections. It is therefore helpful to have a basic working knowledge of your company's data so that you can relatively quickly make intelligent decisions about what sort of discovery requests you can respond to and which you need to push back on, and how to identify responsive records. When we talk about knowing your data, what sort of questions should you be asking? For example, what types of data repositories does your company have? How is data stored in those repositories? In what file formats? How is data accessed or extracted from those repositories? For example, can the data be rendered as a report, or does it have to be generated in the form of raw files? What communication systems do your employees use? What types of instant messaging systems? Do your employees have company-issued devices? Are they communicating about company business on their own personal devices? What sort of archived or offsite data does your company have? How much time and money would it take to obtain that data in a usable and accessible format? What are your document retention policies? How far back does your data go? These are just examples, but there are others. These are main ones, though. Knowing this information, or at least knowing who to ask to get this information, will help you respond quickly in the event your company receives a request for e-discovery. Setting aside whatever statutory or regulatory record retention obligations your company may have, neither the federal nor the California state rules of procedure impose an obligation to preserve what is referred to in the rules as electronically stored information, or ESI, which is essentially every sort of record that isn't a hard copy document or tangible item, when there is no litigation on the horizon. So when does the duty to preserve attach? Under the federal rules of civil procedure, the duty to preserve attaches from the moment that litigation is reasonably anticipated. The California rules of procedure do not impose an explicit duty to preserve documents in anticipation of litigation, although the recent trend is for California courts to look to the federal rules and apply the same obligations to preserve documents in advance of litigation. Both federal law and California law impose sanctions for failing to preserve ESI. Under Federal Rule of Civil Procedure 37, a failure to take reasonable steps to preserve ESI in anticipation of litigation, even where such failure was not intentional and merely negligent, can result in monetary sanctions or evidentiary sanctions where the information is not available from another source. If the court further finds that the failure to preserve was done for the purpose of depriving the other party of evidence, the court can instruct the jury to presume that the evidence was not favorable to the party who failed to preserve it, and can even dismiss the action or enter default judgment against the party who failed to preserve the evidence. Similarly, under California law, the court can instruct the jury that it can consider whether evidence was concealed or destroyed, and that they can assume that the evidence would have been unfavorable to the party that concealed or destroyed the evidence, if there's substantial evidence that that is in fact what happened. These types of instructions can be very impactful for a jury. While I think that juries do usually take seriously their duty to weigh evidence and apply the law as instructed by the judge, I think as a general matter, juries are trying to figure out which party is the bad guy and which party is the good guy. A jury may not fully grasp all the details of a complex underlying commercial dispute, but a jury will be able to understand the import of a party destroying potentially inculpating evidence. Like they say, it's not the crime, it's the cover-up. Once a jury has seen evidence that a party intentionally destroyed records, it will be difficult for that party to convince the jury that it's not the bad guy in the litigation. Incidentally, the intentional destruction of evidence which is often referred to as spoliation. And California attorneys are under an independent ethical duty to ensure that their clients do not spoliate or destroy evidence. The general duty of competence that California attorneys have also includes and requires, and I quote, among other things, and at a minimum, a basic understanding of and facility with issues related to e-discovery, including the discovery of electronically stored information. I further note that even when there is no duty to preserve in anticipation of litigation, a failure to preserve evidence in violation of some other regulatory or statutory record retention obligation can also give rise to an inference of spoliation or the intentional destruction of evidence. Moreover, in some states, and in federal courts sitting in diversity in those states, a failure to preserve evidence can also expose a party to tort claims. Whether litigation is reasonably anticipated is an objective standard that looks to the relevant facts and circumstances to determine whether litigation is likely. The mere possibility of litigation is insufficient. This standard operates somewhat differently for potential plaintiffs and potential defendants. For potential defendants, the reasonable anticipation of litigation standard focuses on whether there is credible evidence that future litigation is probable. In some contexts, this is a straightforward inquiry. For example, a company receives a summons to appear in court, or a letter explicitly threatening a lawsuit. I should also note here that although the standard is reasonable anticipation of litigation, the duty to preserve can also be triggered where a company receives a subpoena or receives notice that it will be subject to a governmental investigation. In those instances where there is a clear threat of litigation or investigation, the company should reasonably anticipate that it may be subject to a lawsuit or investigation and is therefore obligated to take reasonable steps to preserve its ESI. In other contexts, however, whether the duty to preserve has attached is more ambiguous due to the broad, fact-specific, and discretionary nature of the standard. And the courts are not necessarily perfectly consistent in drawing the line between possible litigation and probable litigation. For example, a letter from an attorney asserting that the recipient was infringing his client's trademark, and which suggested a negotiation between the parties to avoid litigation, did not trigger the duty to preserve, or at least was held not to in that particular instance. Conversely, a letter noting that the sender had consulted with attorneys and could obtain substantial damages if he were forced to file suit was sufficient to trigger the duty to preserve, even without an explicit threat to sue. Other circumstances may also give rise to the reasonable anticipation of litigation. The filing of an EEOC charge likely puts a company on notice of future litigation. If there's a fire and an investigation determines that the fire was due to a lapse in safety precautions, there's a duty to preserve evidence related to the fire. If there's an accident on the job, there may be a duty to preserve evidence related to the accident. Companies may also have a duty to preserve documents related to, for example, product defects, where they have been subject to lawsuits regarding those product defects in the past. One example of a case drawing a pretty broad boundary for what constitutes the reasonable anticipation of litigation is Philip M. Adams versus Dell. In that matter, which is a patent infringement suit, there was a defect in floppy disks, some of you may remember what those are, that led to several prominent lawsuits. The plaintiff developed technology to address these defects and filed a patent application for that technology in 2001, eventually receiving patents covering that technology. 4 years later, in 2005, the plaintiff issued a cease and desist letter to the defendant, demanding that it cease infringement of its patents. The defendant argued that the duty to preserve did not begin until it received the cease and desist letter in 2005, but the court rejected that contention, finding that the notorious nature of the defects, the plaintiff's patent application, and the industry-wide interest in that technology put the defendant on notice that it could be subjected to a patent infringement suit regarding the technology it developed to address these same floppy disk defects. For potential plaintiffs, the reasonable anticipation of litigation inquiry is somewhat different. And typically the point at which a plaintiff reasonably anticipates litigation is some point in advance of actually filing the litigation. Courts focus on when the plaintiff determined, or reasonably should have determined, that legal action is appropriate, which depends, again, on the particular facts at issue. For example, plaintiffs who were sophisticated investors into hedge funds were under a pre-lawsuit duty to preserve where one hedge fund had declared bankruptcy, a complaint had been submitted to the Virgin Islands government about the hedge funds, and other investors had retained counsel. The duty to preserve also attaches when a party forms definite plans to file a lawsuit. While the reasonable anticipation of litigation inquiry is fact-specific, and it is not practical to generate an exhaustive list of the factors a court may consider in making that inquiry, the following factors are often pertinent: the nature and specificity of the complaint or threat. A complaint that is more realistic or more specific is more likely to put a company on notice that litigation is likely. The party making the claim. Is this a business entity that the receiving party, has a lot of transactions with? Is this a random, third-party complaint from an anonymous individual? Courts also look at the business relationship between the parties, whether the threat is direct, implied, or inferred, whether the party making the claim is known to be litigious. Obviously, a party that is notoriously litigious is more likely to be serious about its litigation threats. Courts also consider whether a party could assert a claim or is aware of the claim, the strength, scope, or value of a known or reasonably anticipated claim. The greater the gravity of the claim, the more likely it is that it is going to matriculate into a lawsuit. Whether any employees had expressed the belief that litigation may ensue, for obvious reasons. Whether the company has learned of similar claims, the experience of the industry at large, and press and/or industry coverage of the issue either directly pertaining to the defendant or the complaints brought against someone else similarly situated in the industry. One thing that can make a company's determination of whether the duty to preserve evidence has attached more defensible is if the company has a formal policy setting forth the process for making that determination. Decisions made as part of a consistent, pre-established policy will at least appear to be more reasonable than ad hoc decisions. Whether a company is on notice of facts known to its employees depends on both the nature of the facts and the employee's roles within the company. Where the employee acquires the information while acting within the course and scope of his authority, and the information relates to matters within the course and scope of his authority, the employer is chargeable with that information. It is therefore essential that employees who become aware of potential claims against the company relay that information up the chain in a timely fashion to ensure that the company has an opportunity to comply with its evidence preservation obligations. Once a company reasonably anticipates that it will be subject to litigation, let's say, for example, that it is served with a lawsuit, it acquires a duty to preserve evidence. The duty to preserve relevant evidence originates in the common law and, consistent with the fact that the American legal system permits broad discovery, the duty to preserve is also quite broad. It extends to records that the company knows, or reasonably should know, are relevant to the claims and defenses in the litigation, or potential claims and defenses in the litigation, records that reasonably could lead to the discovery of other admissible records, and records that are or likely will be the subject of discovery requests. The duty to preserve requires a party to identify, locate, and maintain information and tangible evidence. This duty includes the obligation to institute a litigation hold to suspend routine record destruction and ensure the preservation of relevant documents. Some courts consider the failure to issue an internal litigation hold to be grossly negligent. Other courts have found that the failure to issue a litigation hold is merely negligent where the relevant documents are otherwise preserved. The duty to preserve extends to a company's lawyers and its corporate managers, who have a duty to convey the preservation obligation to other employees. When determining which records to preserve, companies should consider those records that are within their possession, custody, or control, because Federal Rule of Civil Procedure 34A permits parties to request records within the receiving party's possession, custody, or control. All types of records are discoverable under Rule 34. Any documents or ESI, including writings, drawings, graphs, charts, photographs, sound recordings, images, and other data or data compilations stored in any medium from which information can be obtained, and any tangible things constitute discoverable information under Rule 34. Effectively, any writing reduced to some medium is discoverable under Rule 34. The process of identifying relevant documents to preserve requires a careful consideration of the particular claims and defenses to identify the types of relevant subject matter. The investigation typically begins with interviewing key custodians and data managers who are most likely to have relevant information and topics, and includes identifying other relevant custodians and documents based on those interviews. A party must retain all relevant documents in existence at the time the duty to preserve attaches, and any relevant documents created thereafter. The process also typically focuses on documents within the company's own possession or custody first, and then expands outward to those documents in the possession of third parties that are within the company's control. Documents in the possession of third parties are within a company's control when that company has the formal or de facto ability to demand those documents. For example, courts will typically find that a principal has control over its agent's records. Relevant third parties can include outsourced service providers, storage facility operators, and application service providers. The reasonableness of a company's data preservation efforts is a case-by-case inquiry that depends in part on proportionality, i.e., whether the preservation efforts are proportional to the needs of the litigation. The standard for judging proportionality in discovery is set forth in Federal Rule of Civil Procedure 26B1, which states discovery must be proportional to the needs of the case, considering the following factors: the importance of the issues at stake in the litigation. This basically looks at the gravity of the issues involved in the case and the number of people who will be affected. For example, a case concerning a constitutional question that would affect millions of people would be considered to be more important than, for example, a low-stakes contractual dispute between two businesses. Another factor in the proportionality analysis is the amount in controversy. This factor is pretty straightforward. The greater the amount in controversy, the greater the obligation the company has to preserve records. Conversely, the preservation obligation is more limited where there is a smaller amount at issue. For example, it is very unlikely that a court will find a failure to comply with the duty to preserve, where preserving potentially relevant archive data would cost $1 million and the amount in controversy in the suit is only a few $100,000. Another factor courts consider is the parties' relative access to information. The duty to preserve records is relaxed, where the requesting party already has access to those records, either publicly or from a third party, that is not within the receiving party's control. Conversely, a court is more likely to find a duty to preserve where those records are exclusively within the receiving party's possession. Another factor courts consider in the proportionality analysis is the party's resources. This factor typically does not weigh heavily in the inquiry, but as a general matter, a court will be more sensitive to preservation obligations where the company has limited financial means, and less sensitive where the receiving party is well-resourced and can easily afford to preserve the records at issue. Another factor is the importance of the discovery in resolving the issues. How critical is the information to the claims and defenses at issue? Are the records potentially dispositive of some key element of a claim or defense? Do they pertain instead to a collateral issue? Are they unlikely to yield relevant information? And finally, courts consider whether the burden or expense of the proposed discovery outweighs its likely benefit. This factor is somewhat duplicative of the other factors and looks at whether the time and money required to preserve the records at issue outweighs the potential probative value of those records. As a general rule, a litigation hold does not apply to inaccessible backup tapes, particularly when information is available from other sources. Similarly, there may be no obligation to preserve transient or ephemeral data that is not kept in the ordinary course of business. For example, in Columbia Pictures v. Burnell, the court refused to find a duty to preserve information temporarily stored in RAM, where the producing party had no reason to anticipate that it would be sought, and the requesting party asserted a duty to preserve RAM only for the first time in its motion for sanctions. Some factors to consider in determining the scope of a hold are the cost to preserve and potentially restore information, the number of individual custodians involved in the matter, the type of information involved, and whether the hold is on active data, historical data, or future data, because the litigation involves future or ongoing business activities. When considering whether to preserve third-party documents, special attention must be paid when those documents reside outside of the United States. Many countries have laws that conflict with the United States discovery requirements, including laws that limit the retention of certain types of information and those that limit the processing or transfer of information to the United States for discovery purposes. For example, the European Directive 95/46/EC governs the processing and use of personal data for all EU member states. That directive requires, among other things, that personal data shall not be kept for longer than is necessary for the purpose for which it is processed, and personal data shall not be transferred to a country or territory outside the EU unless that country or territory ensures an adequate level of protection for the rights and freedom of data subjects in relation to the processing of personal data. Currently, the EU does not consider the United States to have adequate levels of protection, and therefore only allows personal data to be transferred to the United States if some exception applies. It is frequently the case that a prospective plaintiff will issue an evidence preservation letter or demand to a potential defendant, putting the potential defendant on notice that it may be subject to claims and demanding that the defendant preserve relevant electronic evidence. Arguably, the scope of the preservation obligation is limited by the evidence preservation demand. For example, if the evidence preservation letter only identifies certain subject matters of documents, the recipient may not be under an obligation to retain records related to other subjects. Similarly, courts have held that the types of records that the recipient is obligated to preserve can be limited by the evidence preservation demand. For example, where an evidence preservation demand did not specifically reference social media accounts, the court found that the defendant's failure to preserve its Facebook account did not constitute spoliation or the intentional destruction of evidence. However, while an evidence preservation demand can inform what a party is reasonably required to preserve, the company is still under an independent obligation to make reasonable efforts to identify and preserve potentially relevant records, and should not presumptively rely on an evidence demand letter as setting forth hard limits on the duty to preserve documents. Conversely, if a company is a potential plaintiff, it would be well advised to make sure that any evidence preservation demands it sends out are clear, thorough, and specific about the relevant subject matter of the potential claims and the types of evidence that the recipient is obligated to preserve, because a court may later rely on the evidence preservation demand to limit the scope of the recipient's preservation obligations. It is now well established that metadata is discoverable. Metadata literally means data about data, and in this context refers to the sort of information associated with a document other than its contents that is often automatically generated when creating or exchanging documents. There are two types of metadata. There is metadata that is embedded within a digital file, which is referred to as application metadata. Application metadata can travel with the file as the file is copied from one digital device to another, as long as it is copied in such a way as to preserve the metadata. Application metadata can include information such as the author of the document, whose files the document was stored in, the date the document was created, and the dates that the document was edited. The other type of metadata is systems metadata, which is metadata that is stored externally and is not embedded within a file. Can documents such as the file name, file size, and file usage. Courts generally require the production of metadata so that the parties are on an even playing field. The applicable principle is that the receiving party should have the same ability to access, search, and display the information as the producing party. It is therefore important when preserving records to ensure that they are preserved in a way that maintains the metadata for those records. The duty to preserve also extends to instant messaging systems where there are relevant communications occurring on those systems. Parties have been sanctioned for their failure to preserve instant messages. Note that this duty can extend beyond just the responsive messages themselves to include other messages necessary to provide context. Companies may also have a duty to preserve the relationship between hyperlinks and the documents in which those hyperlinks were embedded. The law on this topic is still developing, and it can be technically difficult to maintain the relationship between a document and an embedded hyperlink. Some courts, however, have held that hyperlinks must be produced along with the documents in which they are embedded, or at least that companies must make reasonable efforts to do so. Moving forward chronologically, once a party has received a lawsuit and has taken reasonable steps to ensure the preservation of its relevant records, the focus turns to discharging that party's discovery obligations. Before we get into the nuts and bolts of discharging a party's discovery obligations, I wanted to talk about a few general strategic or philosophic points regarding responding to e-discovery. There are generally two schools of thought. Some believe that the correct approach to discovery obligations is to be as stinting as possible, to assert every objection and to narrowly read any request for discovery, and just generally to obstruct the discovery process as much as possible. These people believe that the documents you don't produce can't hurt you, and therefore the safest approach is to resist discovery at every opportunity. Others think that this approach basically constitutes gamesmanship, and that it makes the responding party appear as if it has something to hide. These people believe that discovery can be very expensive and a huge time suck, which is true, and therefore that the correct approach to discovery is to be as forthcoming as possible without spending substantial time fighting about the scope of discovery or reviewing documents or familiarizing oneself with the contents of one's records before producing them. The turn everything over approach has obvious downsides. I will give you just one example of a company that was too forthcoming in discovery. Presumably, most of you know that Enron was an energy company based in Houston that appeared to be very successful before declaring bankruptcy in 2001, after it came out that it was engaged in pervasive accounting fraud and insider trading. Among other things, Enron manipulated its accounts to hide substantial losses. Enron was subject to an investigation that included Enron's accounting firm at the time, Arthur Andersen, which at the time was one of the then Big Five accounting firms. Arthur Andersen was represented in that investigation by a major law firm, which recommended that Arthur Andersen freely share records with the government as a sign of good faith. It turned out that these records showed that Arthur Andersen was involved in Enron's accounting fraud, which ultimately brought down Arthur Andersen and is the reason why there are now only the Big Four accounting firms. While this is a dramatic example of what can happen if a company discloses too much, it serves to underscore that turning over information in discovery can expose a company to liability. Discovery can, for example, sweep up documents that may reveal wrongdoing by employees in unrelated, previously undisclosed matters. There may also be documents that simply make the company look bad. One thing that has remained true through my 15 plus years of practice is that people continue to put incredibly alarming things in their work emails, despite being warned repeatedly not to. And while documents can be produced as confidential subject to a protective order, it can be difficult to control what happens to documents once they are produced. The alternative approach of resisting discovery at every turn, while that can feel like a safer approach, also has substantial downsides. As an initial matter, more discovery disagreements will inevitably lead to more discovery costs. Typically, discovery disputes entail an extensive back and forth between counsel, ultimately leading up to motion practice, with motions to compel and the potential of sanctions, including monetary sanctions, associated with those motions. A party that unsuccessfully brings or opposes a motion to compel is subject to monetary sanctions in the form of the other party's attorney's fees, unless the court makes a determination that the unsuccessful party acted with substantial justification or that circumstances will otherwise make the imposition of a sanction unjust. That is the standard in California state court. Similarly, in federal court, if a motion to compel is granted, or if the disclosure or requested discovery is provided after the motion was filed, the court may require the party or deponent whose conduct necessitated the motion, the lawyer advising the conduct, or both, to pay the movement's reasonable expenses incurred in making the motion, including reasonable attorney's fees, unless, 1, the movement filed the motion before attempting in good faith to obtain the discovery without court action, 2, the opposing party's position was substantially justified, or 3, other circumstances make the award of expenses unjust. If the motion is denied in federal court, the court must require the movement, its attorney, or both to pay the other party's reasonable expenses incurred in opposing the motion, including attorney's fees, unless the moving party's position was substantially justified or other circumstances make the award of sanctions unjust. Often a cost-benefit analysis will not favor an obstructive approach. An obstructive approach can also be strategically disadvantageous. Attorney time is not an infinite resource, and time devoted to collateral discovery disputes can often be better spent focusing on the key issues in the case. A myopic focus on defending against discovery requests can also distract a party from marshaling its own evidence that it needs to support its claims or defenses. This is a repeat strategic error in litigation. Parties often focus too much on the costs associated with responding to discovery and narrowing the scope of their responses to reduce those costs as much as possible, without considering whether the types of documents they are refusing to produce may actually help them. For example, a company in a contract dispute may object to producing communications generated prior to the formation of the contract before realizing that those communications contain key parole evidence relevant to interpreting the contract between the parties. Another significant downside to generating discovery disputes is that it can really tick off your judge. The rarest and most valuable commodities in litigation are the judge's time and attention. As a young litigator, I was advised to always remind the court at the beginning of every hearing what the case is and why you're before the court that day. That is good advice that I honestly did not at the time believe because I did not appreciate what a court's workload looks like. Courts are generally dealing with a veritable fire hose of matters. Habeas claims by prisoners, pro se complaints, criminal sentencing, etc., and typically do not have as much time as you and they might like. It is important to also bear in mind, as important as your case is to you, it is but one of the many, many cases that a judge is handling at any given time. Your case is not the court's priority, and your discovery dispute even less so. To put it bluntly, courts hate discovery disputes, and if the court feels that one party has caused the dispute by being unreasonable, that party will not earn the judge's love and affection. Discovery disputes are thorny. They are often very fact-specific, and frequently there is no legal issue that allows for their ready resolution. Courts also generally have little tolerance for squabbling between the parties and are likely to be frustrated with the parties' inability to resolve these disputes themselves. It is therefore very important to be judicious, pun intended, in determining what discovery disputes to raise before the court. Every litigation is different, and there may be particular circumstances where full disclosure, or conversely maximum resistance, is the correct strategic play. For example, you may have an opponent that is too reticent to bring a motion to compel, which would allow you to take more aggressive positions. There may also be matters that are subject to a lot of public attention, where an overly obstructive response would have substantive negative impact on public relations. It is also sometimes the case that matters can be won in discovery, for example, by thwarting your opponent's efforts to obtain information or by shaking loose inculpating evidence that forces the opposing party to come to the negotiation table to discuss settlement. By way of further example, I represented the defendant in a matter where the evidence on liability was, let us say, not favorable, but there were strong legal arguments that the plaintiff was otherwise not entitled to its desired remedy as a matter of law. So we pushed back hard on the discovery requests for the unhelpful documents, including by agreeing to first produce other documents that were more innocuous, and positioned ourselves for an early summary judgment motion. Ultimately, we obtained a favorable ruling on the summary judgment motion before the unhelpful documents saw the light of day. As a general matter, however, the correct approach is somewhere in between, neither too obstinate nor too yielding. The mental construct that I like to use when deciding how aggressive versus cooperative to be in responding to discovery is that, at least as an initial matter, I want to take the most aggressive position I can that is not going to upset the judge. In other words, would I feel comfortable articulating this position in court, or is this the sort of position that's going to make the judge look at me funny? When I am propounding discovery, I also look at the responses of the other party through the same lens. And if I identify an area where I think the other party has gotten over their skis, I will at least give serious thought to trying to get that dispute in front of the court. Moreover, both federal and California state law requires parties to meet and confer regarding the discovery of ESI. Among other things, the parties are required to discuss the sources, scope, and type of ESI that has been and will be preserved, considering the needs of the case and other proportionality factors, including date ranges, identity, title, and number of potential custodians, and other details that help clarify the scope of preservation. Any difficulties related to preservation, such as the burden involved in preservation, under Federal Rule of Civil Procedure 26B2B, a party need not provide discovery of electronically stored information from sources that the party identifies as not reasonably accessible because of undue burden or cost. Parties may also need to discuss the search and production of ESI, such as any planned methods to identify discoverable ESI and filter out ESI that is not subject to discovery, like the use of search terms, or whether ESI is stored in a database that can be produced by querying the database and producing discoverable information in a report or exportable electronic file. Parties also need to discuss the phasing of discovery, so the discovery occurs first from sources most likely to contain relevant and discoverable information, and is postponed or avoided from sources less likely to contain relevant and discoverable information. Parties must also discuss the potential need for a protective order and any procedures to which the parties might agree for handling inadvertent production of privileged information or other privileged waiver issues pursuant to Federal Rule of Evidence 502D or E, including the possibility of a 502D order. Under Rule 502D, the parties may agree that the disclosure of attorney-client privileged information or attorney work product is not a waiver of the privilege or protection. This type of agreement, which is commonly referred to as a clawback agreement, is binding only on the parties unless the court enters an order to the same effect. Typically, parties will negotiate a clawback agreement as part of a protective order. Regarding ESI, the parties must also discuss opportunities to reduce cost and increase efficiency and speed, such as by conferring about the methods and technology used for searching ESI, and they must also discuss privilege issues. It is a best practice to memorialize whatever agreements the parties reach regarding ESI in an ESI protocol that can be entered by the court. Federal law requires that these meet and confer discussions happen relatively early on in the litigation. Rule 26F requires the parties to meet and confer regarding discovery, including the discovery of ESI, at least 21 days before a scheduling conference is set to be held or a scheduling order is due under Rule 26B. Rule 26B2 requires the court to issue a scheduling order within the earlier of 90 days after any defendant has been served with the complaint or 60 days after any defendant has appeared. Therefore, the parties must be prepared to meet and confer about ESI within approximately 70 days of being served at the latest. Federal Rule of Civil Procedure 26A also requires, in most federal lawsuits, that the parties make an initial disclosure of information to the other party within 14 days of the Rule 26F conference, or approximately 85 days after the defendant is served with a lawsuit at the latest. This initial disclosure is required to contain the name, phone, and address of each individual likely to have discoverable information that the party may use to support its claims and defenses. The disclosure must also include a copy, or as more commonly done, a description by category and location of all documents, ESI, and tangible things in the disclosing party's possession, custody, or control that it may use to support its claims or defenses. California state procedure does not have an equivalent requirement to Rule 26's initial disclosures, although the parties can agree to such an exchange, but it does allow parties to serve discovery requests very early in the litigation, and thus a party in California can also be required to respond to discovery shortly after litigation is initiated. Plaintiffs may serve interrogatories or document requests, which are often referred to as inspection demands in California procedure, on a defendant 10 days after serving that defendant with a complaint. A defendant may serve interrogatories and inspection demand. A defendant may serve interrogatories and inspection demands at any time. The standard for discoverability in both federal and California state court is broad. Pursuant to Code of Civil Procedure Section 2017.010, California permits the discovery of any matter not privileged that is relevant to the subject matter involved in the pending action or to the determination of any motion made in that action if the matter is either itself admissible in evidence or appears reasonably calculated to lead to the discovery of admissible evidence. Section 2017.010 specifically notes that discovery may be obtained of the identity and location of persons having knowledge of any discoverable matter, as well as the existence, description, nature, custody, condition, and location of any electronically stored information. Pursuant to Federal Rule of Civil Procedure 26B1, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering those proportionality factors that we discussed earlier. While the standard for discoverability in both federal and California state court is broad, discovery in California courts is substantially more expansive. As an initial matter, California courts typically take a much broader view of what information is relevant to an action than federal courts. California courts have held that the scope of permissible discovery is expansive and have instructed that the relevant standard is to be applied liberally in favor of discovery. California courts have even held that discovery that amounts to a fishing expedition may be permissible. The court in Norton rejected the objection that the discovery at issue was a fishing expedition and noted that courts have affirmed at least some level of permitted fishing. The court also noted that California courts have resolved any doubt in favor of permitting discovery based on the view that if an error is made, it is better to err in the favor of disclosure. California procedure also places fewer limits on discovery. Both California and federal court allow parties to propound document requests, interrogatories, which are written questions, and requests for admission, and requests for inspection. California procedure also has form interrogatories, which are standard sets of pre-written questions that allow a party to quickly propound a number, dozens of interrogatories with very little effort. In federal court, a party may only serve 25 interrogatories. In California, a party may serve as many form interrogatories as it may like. In addition, it may serve 35 special interrogatories or interrogatories crafted for that matter. Exceeding that limit, however, is very easy, as a party only needs to include in excess of 35 interrogatories a declaration stating that additional interrogatories are necessary due to the complexity of the matter. Courts are typically very permissive about allowing parties to exceed the 35 interrogatory limit. Another significant difference between California and federal discovery is that California places no presumptive limits on the number of permissible depositions. The federal rules of civil procedure, as previously mentioned, place specific limits on the discovery of ESI. Federal Rule of Civil Procedure 26B2B provides that a party need not provide discovery of electronically stored information from sources that the party identifies as not reasonably accessible because of undue burden or cost. If the other party challenges that assertion, it becomes the withholding party's burden to show that the information is not reasonably accessible because of undue burden or cost. If that showing is made, the court may nevertheless order discovery from such sources if the requesting party shows good cause, but it may impose certain rules on that discovery and may require the parties to share costs. California and federal law require a party responding to discovery to make reasonable efforts to locate responsive documents. The first step in responding to e-discovery, requests for e-discovery, is to identify the potentially responsive records, bearing in mind the broad scope of discovery. It is also important to bear in mind that even a simple failure to ask the right questions can lead to sanctions. Try to think expansively about what sort of relevant data your company may have. Also bear in mind that most of the people you will be interviewing will not be attorneys and will not have a lawyer's understanding of the issues in the litigation. Try to provide digestible but complete information regarding the litigation to help your employees understand what sort of documents may be relevant. When identifying potentially responsive records, it is important to consider whether the request for discovery triggers any obligations to any third parties. For example, are there contractual obligations that require the company to keep the information confidential or provide notice to the counterparty? Does the information implicate the privacy rights of third parties? Do the records contain protected health information, for example, that would be covered by HIPAA? Another step in the process of responding to discovery is issuing a formal written response and objections to the discovery requests. Among the most common objections are objections to relevance and on the grounds of burden. But again, objections on the grounds of burden will require the objecting party to provide evidence of the time and money that will be required to respond to the discovery in order to prove up the burdensome objection. After serving formal objections, the parties are then required to meet and confer in an effort to resolve their disputes. As part of the meet and confer process, parties will typically agree on a protective order to protect confidential information. Once a responding party has identified potentially responsive ESI and has hopefully narrowed and or clarified the scope of discovery requests through meet and confer with the propounding party, the responding party needs to determine which of the potentially responsive ESI to produce. This process can be very expensive and very time-consuming when dealing with a large volume of potentially responsive information. When it comes to reviewing information to produce, the traditional method is to hire contract reviewers to manually review the documents. There are now other technological options that a party can use to reduce the volume and burden of the document review process. One such tool, some tools involve reducing the amount of documents at issue, for example, by combining partial emails into overall complete email threads, deduplication, near match deduplication. There are also methods for reviewing documents or reviewing ESI that involve technology. One method, and I see that I'm running out of time here, so I'll just wrap up with this. But one such method is technology-assisted, what is called a technology-assisted review, which uses an AI program not generative AI or an LLM, but a pre-existing AI technology, to determine which documents are responsive and which documents aren't. Under this procedure, documents are manually reviewed on a relevant, not relevant basis, and then fed into the system so that the system learns which documents are responsive and which documents aren't. A technology-assisted review is recognized and approved by the courts and is a defensible method for identifying responsive documents. However, it is expensive, and it typically involves a lot of manual review because generally teaching the system involves multiple rounds of review. Obviously, a hot topic in e-discovery right now is the use of generative AI, and more specifically, large language model AI, to identify, process, and analyze ESI. There are a number of LLM products out there, some of which have some nifty features. My overall take on the AI ESI products is as follows. They are expensive. We've gotten quotes for ingesting documents into an LLM at 18 cents a document, which can really add up when you're dealing with millions of documents. They are arguably too unreliable. While LLMs can generate impressive results, they can also hallucinate and produce nonsensical results. Presumptively relying on an LLM to identify relevant documents without any sort of oversight or double check is risky. And using LLMs to discharge one's discovery obligations is not currently defensible because there is a paucity of case law approving or providing guidance for their use. Currently, the law regarding the using LLMs in discovery is unsettled. It would be inadvisable to use an LLM in discovery and risk the possibility that discovery would have to be manually redone if the court ultimately disapproves of the LLM approach. Thank you for joining me today. I will give a final plug for our 6th session, our final session in the series, which will be presented by Kendra Hall, and who's an appellate specialist, and will concern building a winning appeal strategy, a guide for in-house counsel. Again, my name is Jacob Poorman. I very much appreciate your time, and I hope that you have found this to be informative. Thank you.